Hello, everyone. Thank you for joining us. Welcome to our webinar, What Judges Should Know About Elder Abuse. This webinar is being provided by the U.S. Department of Justice Elder Justice Initiative and the Office for Victims of Crime Training and Technical Assistance Center. And with all technology, we may at some point experience a momentary lapse in the webinar. In the event of such a problem, please just be patient with us and remain on the line, and the webinar should resume shortly. We do want to take a moment here to make sure that everyone is connected properly. So if you are having a technical issue, you can feel free to send Jason, our technical specialist, a private chat message in the box on the lower right. We'll also be using that box if you have questions for the presenters at any point during the presentation, and we'll be taking time at the end to address any questions that may be remaining. If you cannot send a chat, you can also access Jason through email at jadams@ovcttech.org. Today's session is being recorded. We make these webinars available on the EJI training website as well as the OVC-TTAC training website. There has been a large series of these webinars for various audiences, so if you haven't already taken a look at those, we encourage you to do that. Stay tuned for others coming in the future as well. At this point, I'm going to turn things over to Andy Mao. He is the coordinator of the U.S. Department of Justice Elder Justice Initiative to introduce himself and our presenters. Andy.
Good afternoon, everyone. As Lori said, my name is Andy Mao, and I'm the coordinator of the Department of Justice's Elder Justice Initiative. The mission of the initiative is to help support the department's many law enforcement and programmatic efforts to combat elder abuse, neglect, and financial exploitation. We do that, as the slide shows, in a number of different ways. Primarily, what we do is create a number of resources for state and local and federal law enforcement and prosecutors, and many, many others who respond to prevent and address elder abuse. All of the materials that we develop and the trainings and the content are all made available on the Elder Justice website, which can be found at www.elderjustice.gov. All of our outreach materials are on there, all our materials for prosecutors, which includes a training series, a video training series for prosecutors, all of our law enforcement materials. There is a rich database of elder abuse research that is available there, as well as materials on financial exploitation and the benefits and toolkits in connection with the use of multidisciplinary teams, which are a critical vehicle for addressing elder abuse. I would also say that all the webinars that we do and have done are taped and made available on the website as well. So to the extent that you have a chance and you've missed a webinar, feel free to go to the website and check those out there. Before I introduce our speaker today, I was hoping that we could do a quick poll and get a sense of who is participating on our webinar today. I see a number of international colleagues, and that's terrific, but this is to get a sense of the backgrounds and professions of those participating. So if you could take a moment and fill that out, that would be great. Now, it's my honor and pleasure to introduce the Honorable Karen Howze, Judge in Residence with the National Council of Juvenile and Family Court Judges. She is a retired judge from the District of Columbia Superior Court, where she served as a magistrate judge for more than 13 years, presiding over elder abuse, all sorts of abuse cases, including child abuse, juvenile abuse, domestic violence, criminal arraignments, and municipal offense cases. Before she was appointed to the court, Judge Howze served as special master in the family court, where she reviewed all abuse and neglect cases to bring them into compliance with the Adoption and Safe Families Act and provided training to judges on the law's requirements. She later served as director of the Adolescent Health Program at the American Bar Association's Center for Children and the Law, and was the principal writer and editor of Help for Teens in Care. As an attorney, Judge Howze represented children in foster care, birth parents, adoptive parents, the mentally ill, and elders in guardianship proceedings as an attorney, a guardian ad litem, and as a conservator. She is the author of Making Differences Work, Cultural Context in Abuse and Neglect Practice, and she was a former newspaper reporter and editor, and a founding editor at the USA Today. It is a real pleasure and honor to have her speak with us. We obviously have had a number of webinars for prosecutors and for law enforcement, but it is a singular opportunity to have the benefit of hearing how judges view these cases and what is important to them. So with that, I would turning over the mic over to Judge Howze.
Well, hello everyone. It's a pleasure to be here, and good to see that we're continuing the education process and development of best practices in the area of elder abuse. Normally, this presentation is actually a part of a 3-day program for judges that OVC funds, and so we're going to smash a lot into a very brief period of time. So be patient with me, and I hope we'll get a chance to address any questions or concerns you might have. So let's get started. Our objectives here this day are to ensure that as a result of this webinar, you will be better able to identify the signs of elder abuse, understand the dynamics of elder abuse to fashion appropriate relief to meet the safety needs of individual victims, and finally, to discuss, promote, and lead efforts to address elder abuse later in life in your courts and your community. So let's talk about the numbers first. The population of older Americans is expanding. You know, we can blame it on this baby boomer generation that everybody talks about and whom I'm a part of. But 1 in 5 Americans will be senior citizens, and that's as defined by the federal government, which generally is 65, by 2030. 1 in 5. Now, in the past century, life expectancy has increased by almost 30 years. The numbers now are pretty much even for men and women in terms of how long they live, which was very different than the past. We can give that to the progress related to healthcare and health innovations. Now, just as domestic violence is underreported in the general population, abuse of elders is also underreported for many reasons. The assumption that we work with is if it's underreported for all, it's going to be underreported for seniors. Now, Jasinski and Dietz in 2003 found that seniors are almost as likely to be stalked as younger people, which I think many people find to be surprising. The big issue here, though, is that seniors' voices are often left out of the national conversation, as well as the local conversation. A few more numbers. Older women are more likely to be assaulted in their homes than younger women. Older women are more likely to be sexually assaulted by family and caregivers than by strangers. Older women victims of sexual assault are more likely to sustain physical injury in addition to psychological injury. Senior incest victims are often dependent upon the abuser for care, and many abusers depend on the elder for housing, which creates problems with motivation, which we'll talk about later. Elder victims of sexual assault are commonly disbelieved due to misconceptions about age, capacity, and due to ageist assumptions. I'm sure none of this is surprising to you. Now, part of the issue with ageism is the assumption of frailty. I don't know how many people have had occasion to have family members or neighbors say, you know, they come and hold my elbow when I am walking out of the grocery store, and I'm not feeble. Well, we have problems figuring out often what is the current status of an elder that shows up in the courthouse. Look at this chart here. It says signs of Alzheimer's and dementia, poor judgment and decision making. Now look across to the other, typical age-related changes, making a bad decision once in a while. We can chuckle at these because there's a thin line, as you see in the chart, between signs of and typical. This often is the burden of those who are responding to elder abuse in the legal system and in the community in general. So dementia is something that occurs because there is either some underlying physical problem or a mental decrease in the person's ability. But that does not mean if you have dementia that you don't have capacity. Alzheimer's, on the other hand, is pretty much permanent and progressive. And there really is nothing that can be done to stave off its progression. Now, at the same time, you also have elders who suffer from depression, either because they are isolated, because they have health problems, or other social issues that affect their ability to deal with their emotional problems. Of course, depression, no matter your age, can be resolved. So throughout this discussion, we're going to talk about pieces of the brain process, but I'm not a doctor, so you're going to have to go someplace else to get the real deal on this. But it is something that is critical when we're talking about capacity, which comes clearly into the purview of the judge's responsibility in these cases. So first, let's talk about why does elder abuse occur and persist. Anybody have any ideas? Please put your comments in the chat box, and we'll monitor them. First, let's talk about how are older people harmed. First are accidents. Well-intended caregivers. Contact with persons with physical or mental health conditions that manifest in aggressive behavior. Elder abuse, physical, emotional, sexual, and neglect, or any number of a combination of these three or four things. The individual who is abusing, they have individual actions that are a bit different than the traditional domestic violence construct. We often see not only power and control, but greed, and that equals often the motive for the abuser. So let's talk about common abuser justifications and excuses. They're not much different than in other abuse contexts, but we're going to spend a minute talking about caregiver stress. For many years, people would justify their behavior by saying, you know, my mom has Alzheimer's and she doesn't want to go to a nursing home, and it's just turned our life upside down. We never have a break. We don't have enough money because she doesn't have enough money. I'm just totally stressed out. That's caregiver stress. Sure. Providing care in these circumstances can be stressful. Sometimes the stress is overwhelming and can lead to problems that nobody anticipated. Caregivers often experience overeating, lack of sleep, their own depression, and you can name a long list of other possibilities. But let's make something very clear. Caregiver stress is not a cause of elder abuse. Abusers use caregiver stress as an excuse to justify behavior so that they will not be held accountable, and also to create sympathy for themselves. Now, abuse is clearly an outcome of caregiver stress, but it is not an excuse for it. Because everyone experiences stress. Most do not abuse, neglect, or exploit the elder that they are caring for or responsible for. Now, the target in these cases where the excuse comes up for caregiver stress is the older adult, not just anyone out and about. It is using this older adult's frailty or dependence to then create an abusive situation. Finally, when you see these cases, generally there is a pattern, not an isolated incident. Something has been going on, just like the dynamics in abuse of other individuals, not elders, that leads up to the ultimate act. Finally, we would not tolerate similar circumstances with children or pets. That may seem a little crass, but this gets to the idea that it can be hidden, the abuse can be hidden because the elder is more dependent than these other categories of people. Now, another thing that we all have to look for is that abusers, like in any circumstance, whether elders or other abusers, create smoke and mirrors. They lie, they manipulate, they charm, they justify behavior, they blame the victim or others. But what we do know is abusers exploit vulnerabilities. So what are those vulnerabilities? We have economic dependency. We have complications because of immigration status. The mom may not have her immigration status completely resolved, and the abuser will hold that as a threat to get what the abuser wants. There is also the fact that elderly folks may distrust any system, whether it's social service, government, or the court. There is also fear, and just like in domestic violence, outside of this population, there is love, there is hope, and there is the lack of alternatives. We also have religious pressure. Many folks within faith communities may pressure people, and maybe not with ill will, but not understanding the dynamics of abuse. Family pressure also is a reality. So, what are judges looking for? Judges see these cases when they show up in court across all platforms. This is not just criminal. It is not just probate. It can show up in juvenile, where the elder is caretaker of a grandkid, and the grandkid may be acting in a coercive or abusive way. It can show up in family court. It can show up in domestic violence cases where an elder person comes in for a protection order. We are looking as judges across these platforms for undue influence. Now, what is undue influence? Undue influence is a pattern of manipulative behaviors that enable the abuser or exploiter to get a victim to do what they want, when they want, even when the victim's behaviors are contrary to his or her previous beliefs, wishes, and actions. We're going to get back to previous beliefs, wishes, and actions on a number of fronts here today. But undue influence does not require that the person be somehow lacking capacity. This is manipulation, undue influence. But that is one major area where abuse can occur. Now, what is the evidence of undue influence? The judge has to ask, make sure they receive information related to the financial records of the person, the mental health records of the victim, medical records of the victim, tax records, loan applications. There may even be some toxicology issues and past civil litigation. Now let's talk about capacity, because that's where things get a little murky. For evidence of capacity, now notice I did not say incapacity. We're framing this so that we're looking for whether this person has capacity, not whether the person is incapacitated. And most statutes talk about capacity. A determination of capacity is not a determination of competence. Capacity is actually on a continuum of decision-making abilities. So I might today have capacity to drive, but I might not have the capacity to effectively balance my checking account. Now that might be a personal problem, but we won't go there. Let's also look at this. Capacity is situational. We have to ask as judges and as social workers, lawyers, what is actually happening here today? What is happening now? It also has context. And this one is a bigger one than many others. What was the person's life history like? What was that person's life experience? What kind of choices did this person make before? And that is very fact specific. So you have somebody that decides they're 75 years old, they live with their nephew and his wife and 2 kids, and they are living in their home, and the elder's home, that he'd rather just go out and basically ride the rails. And he picks up women here and there and has a good time, and the women take his money, and he can't figure out, is he lacking capacity? No. This gentleman may be making a real choice to be and have the lifestyle that he's decided. Did he do this kind of stuff before? Well, it turns out when he was younger, yeah, that's what he did. So when the relative who's living in his house complains and wants there to be a guardianship, the judge needs to look at the full context of this person's life. Now, the situational part of the example I just gave is based on listening to the elder who says, they treat me badly. I can't stay in my own house. Without that elder's voice, the issue of capacity would be a little more difficult to resolve. Now, capacity also varies by the complexity of the task that the elder is asked to do. The more significant the decision and the consequences of the decision, the higher level of capacity is required. So we have to also look at what is being asked of the elder. Now, mental capacity includes the ability to think clearly, recall accurately, organize thoughts, express thoughts through communication, plan and execute actions. That makes sense. But what we also know, capacity can fluctuate. There can be medical conditions or illnesses. For example, a person can have a urinary tract infection, and their mental state will maybe appear to be one that is either dementia or somewhere on the spectrum leading to Alzheimer's. But in fact, with medication, that person's condition and stability will change even in terms of their mental capacity. It also can be medication. The medications may not match together and may cause a problem that looks like capacity. It also can be the time of day. Events in a person's life can trigger what appears to be capacity issues, such as grief, loneliness, isolation, Experience and education may be related to the ability to understand complex financial transactions. So if I don't have enough skill and did not have enough skill as a 30-year-old to handle financial things, it does not mean now that I'm 80 that I can't, that somehow that is a capacity issue. It actually may be a functioning issue. So we look at things like literacy and the extent of education. Language capacity may present differently when the person is being interviewed, whether it's legally, socially, or mental health or physical health professionals. We also have an element that comes into these cases that is called self-neglect. And that's where the Adult Protective Services, and it's pretty much in all the U.S. Communities and territories, where social workers are asked to go out and check on pretty much the well-being of the person, whether the person lives alone or is living with someone else. Self-neglect occurs when a person fails to meet his or her own physical, psychological, and or social needs. But people can also, remember the guy who traveled and went out with the ladies and spent his money wanting to get away from his relatives who were living in his house? Self-neglect can also be a choice. And that choice, as we'll talk later, should not be taken away. The evaluation is done to make sure that the person can be safe and also that no one is pushing the neglect to the point that it really is self-neglect, it really is abuse. All right, what are the signs? You see them there: dehydration, malnutrition, hypothermia, hyperthermia, excessive dirt or odor, hazardous, unsafe, or unclean living conditions, inadequate or inappropriate clothing, and the absence of needed devices, eyeglasses, hearing aids, dentures, or prosthetics. Unexpected or unexplained deterioration of health. Maybe the person stops taking their medicine. Bed sores, signs of excessive drugging, refusal to take medication or other drug misuse. Now, we're talking about all of these things, but would these be signs possibly of abuse, rather than the elder doing something or failing to do something for themselves? Now, the danger for courts in this self-neglect area and discerning which one it really is that you make a mistake when you fail to ask the questions about what looks like self-neglect or may be presented as self-neglect by a relative or even by a social worker, that there are not enough questions asked to make sure that this is not a sign of abuse. Now, intervention in cases of self-neglect must always recognize the rights of the elder. That's why I made that comment before, that self-neglect, I can choose to self-neglect. But the court has to be sure that that is the person's choice. When legal considerations have been respected, family, community, and social services, along with healthcare interventions, can, in many cases, help make the situation better. That's when we wrap ourselves around the elder and find a way for community services. They may be neighborhood services, they may be elder program that the jurisdiction runs, they may be some connection to the hospital, social work set up for gerontology. We have to make sure as judges that when we ask these questions and self-neglect comes up, that we know the resources that should be used in the community to assist this person if indeed it is self-neglect. And if it's abuse, we have to know those same resources. Now let's talk about guardianships, because they are extremely difficult when we talk about the autonomy of an elder, whether being abused or not. If the judge determines that a subject lacks capacity, the judge must then consider all of the options to best preserve the elder's dignity, keep the person safe, and protect his or her interests, whether financial or physical. Maybe the person needs help with finances, but does not need a guardian who is going to be responsible for their physical care. Maybe the person only needs that guardianship until, remember the urinary tract example, only needs that guardianship until the health stabilizes. This means that judges and all parties engaged in these cases have to drill down. And these are the kinds of questions that all parties need to be asking, including asking them of the elder. Is guardianship necessary and helpful? Is it a medical cause? Is this temporary or an emergency? Who's going to report on the status of the guardianship and the ward once the guardianship is entered? And how frequently will that person report? Is the reporting and accountability that's provided, whether it's a professional who is the guardian or a family member, is that based on some court rule, or is it based on the judge's assessment of what this particular ward needs and the evaluation of when and if the guardianship can end? Your observations as a judge, your observations as an attorney, a social worker, are all part of this mix. There's also myriad numbers of other issues that could be raised. Can you all think of any of those? And please feel free to put them in the chat box. Now we have a comment here that I think is worth talking about. We have a person who indicates that judges don't know the law about elder abuse. Well, let's talk about that for a minute, because the reality is this is new. Courts have been changing the laws on the criminal end, adding enhancements where a person over a certain age is involved in an abuse situation. Elder abuse, when I practiced law in D.C. back so many years ago, it was very difficult to get, we had our prosecutors to file when I might have a ward that I was responsible for. It was very clear that that ward was being abused or engaged with someone who was exercising coercive power and control. Today in D.C., and I think this is true in other places, that would not be the dynamic. If a guardian or an attorney called and said, I think something's going on, there would be a response. And that's partially because of the work that OVC and many organizations have been doing to enlighten communities about need for a coordinated response to elder abuse, just like we had with DV many, many years ago. All right, remember now, let's go back. The capacity is situational, it's contextual, and it varies by complexity of the task or decision to be made. So what has to happen in these cases, and I think this is difficult whether the case is in probate or family or criminal. We have to balance the protection of the elder person so that it is not paternalistic. These are not children. It is a very different approach than we have with child abuse and neglect. We have to balance protection with the autonomy in these guardianship cases. The voice of the elder has to be heard. Now, the goals in these cases are balance well-being with rights, and this gets to the comment about not knowing the law. Well, you got to know the law first, but hopefully we're getting better at that. We have to promote self-determination. We have to provide guidance to guardians. We have to have training for guardians. We have to make determinations about how capacity, if and when capacity can be restored. We have to prevent undue influence, because it's easier in these cases to find that undue influence is going on, and it may be going on in a way that is designed to divert from court involvement. And that's where all of the folks who are involved with elders have to be engaged in the discussion. Now, victim safety and autonomy and protection order cases involving elders, there are no easy answers. When considering whether, when an elder comes in and says they want to drop a protection order, basically it's the same as if an adult came into court. But judges can ask more questions. Maybe ask whether we could modify the order. So it's not no contact now, but it's no assaultive, threatening, abusive behavior. Maybe provide an explanation to the elder of the issues, of issuing the order against the petitioner's wishes. If you are going to issue it against the petitioner's wishes, ma'am, let's come back in a month. I'm going to adjust it, but in a month, let's see how you're feeling. It does not mean that we jump to the conclusion that this person doesn't have the capacity to make their wishes known when they want to drop a protection order. It's all about the questioning. Now, we know that most of these cases, people don't have attorneys, but the judge can inquire. And we need to avoid creating per se rules. For example, if they ask me to drop it, automatically I'm going to drop it. No, the questioning process helps. And the way we explain what our ultimate decision is or negotiate that decision, the better off the elder will be, because we don't know what pressures there may be behind the request to drop the protection order. We also need to ensure that petitioners have multiple opportunities to obtain advocacy. And I think this is a more difficult situation with elders because they may have problems with access to transportation and other things. So the community has to address these gaps or specialized needs in a way that would not necessarily show up in a BB case with younger folks. Success in these cases equals safety. And success is what each victim defines it to be. I as the judge, I as the attorney, I as the social worker cannot define safety. They know where they will feel safe, how they will feel safe. And we have to make it easier for elders to make that definition known to whoever is serving as a helper. Okay, so the next question in this quick-paced overview is what can judges and court personnel, what should they know? Okay, there has to be institutional accountability. What can courts do? Part of this is related to access issues. We have to adapt the court culture to meet the needs of the individual to ensure access to justice. So we do this with other DV cases almost as a rote in many jurisdictions. Question is it safe for the victim to be in the courtroom? Where is the abuser? Is the abuser there? What can be done in that courtroom to make the victim safer in the courtroom? And then we get to things not related to safety, but related to that word access. What about signage? Is the signage adequate throughout the court? We're talking in the hallways, where are the elevators, are the forms in large font? Are the interpreters being used appropriately in a case where there's either a language issue or hearing issue? though a person sits and nods their head as though they're understanding, maybe there's no reason not to ask, do you need anything to hear better? Because you can look at a person and see they may be nodding their head, but they may not really understand. Now, are there any special accommodations needed? Example, oxygen, hearing assistance, amplifiers. Now, where is it the best for the elder to sit to maximize access? There's a story of a judge who I believe is from, well, I know she's from North Carolina. She handles these kinds of cases, and she'll come down from the bench and sit near the elder because she doesn't want that person to have to strain and not hear what the proceedings are. It has worked effectively. We have to be a little bit less formal often than in normal youthful circumstances because we have to acknowledge the special needs of the elder in these cases. Now, again, on accommodations, a lot of jurisdictions have done interesting things around accommodations. I talked about that one judge from North Carolina. Some places have relocated services because some courthouses don't have elevators. So they move the courtroom for these kinds of cases to a place that is on the ground floor. That sounds so simple, but it really makes a difference in engaging the elder in the process, which is probably quite overwhelming. It would be no matter your age, because courts are not friendly places. Another issue is changing the time of hearings. Courts often have, we start our calendar calls at 9 a.m. and we have to be finished for lunch, and then we come back at 1. There are elderly folks who, after 11 o'clock, they're not at their best. After 3 o'clock, they definitely are not at their best. So that's part of knowing what the case is, knowing what's in that individual, and knowing what that individual may need. Now, only way you can know is to ask. So the first hearing, you say, is there a better time of the day for us to have our next court appearance? There are some places that the ward in a probate case, for example, guardianship case, may not be able to get to court. So there is nothing wrong with scheduling hearings, or at least coming up with a process for it, where the elder is. Again, it's case specific, very case specific, and it takes everybody knowing what the full life experience of this elderly person is. Now, one way we get to all of this is the court leading the effort to create a coordinated community response to elder abuse. Elder abuse cases indeed are complex. They demand professionals and community members who can identify solutions, services, and responses that are least restrictive, promote victim safety, and maintain victim autonomy. They also have to provide services that deal with the accountability and responsibility of the abuser. Now, multidisciplinary collaborations can prove most effective because of the increased array of resources that come out during these coordinated efforts. For example, in many places, folks involved in the court system may not know what services are available through even a small faith community that offers meals or offers senior services that is part of their mission. We need to bring those folks to the table as well. We also need to make sure that elders are included in these conversations because they have good ideas about what might meet the needs of people of their generation. Now, it is NCJ, FCJ, and OBC and our other partners have been promoting judicial leadership and suggest that judges consider promoting leading the creation of a coordinated community response team on elder abuse. Because the word is that if a judge asks everybody to come by for lunch to talk about an issue, they will show up. Now, who needs to be at the table? Talked about a few folks, but to really have an effective coordinated community response to elder abuse, we absolutely must have Adult Protective Services because they have a statutory responsibility for this population. We need advocates, and advocates who are schooled in the needs of elder victims and elder abusers. Because the reality is, it's not just the young people who commit elder abuse. It is also the spouses of elders. There was a story that came out of New York, outside of New York City just last week, about a man who went into the hospital and killed his wife and then killed himself. Now, what we have learned is that these kinds of activities, though the reason given was that he was just tired of seeing his wife suffer, that cannot be the automatic, and that's what the advocacy community is learning and trying to make sure that all of us understand these different dynamics in elder cases. We also need to bring in the aging services programs that exist, whether nonprofit or governmental. Financial institutions need to be at the table. Housing, because there can be issues there if, let's say, it's public housing. What is the impact of having an abuse situation in your unit? Might you lose your unit? Or housing if the elder is dependent on the abuser for his or her housing. There are also community organizations, as I discussed earlier. Again, we have to have public health in there and the medical field, the courts, of course, law enforcement, prosecutors, police, the defense bar. You all tell me, am I missing somebody? Anybody else we need to have? All right, so the next question, and I hope we can get into a little bit of conversation. From this discussion so far, what ideas do you have about how the courts and the community, because again, the only way to fix this is a coordinated response, what can be done to improve life for victims of elder abuse and to increase the opportunities for accountability and responsibility for the abuser? Any ideas? Okay, while we're waiting, I think there are a couple questions here that, one question is, I guess my question is, how does the judge go about obtaining this background information, and how should we as victim specialists assist with this? That's an excellent question. One of the things, when I practiced in probate in DC, the judges were very activist in a way. And it wasn't per case, but you knew what the expectations were. And that's where you as a victim specialist come in, because you can, as part of this coordinated community response, come up with, this is what the court needs, this is what the lawyers need, this is what the victim specialists need, and everybody will be on the same page in terms of the gathering of the information. So you would be a very important member of that team as victim specialist, because that will also help inform the judges about what expectations there are in terms of resolution of the elder situation. There's another question about sentencing. How much emphasis can or will a judge put on the additional effects of the crime, causing shorter lifespan, the ongoing effects of the crime? That is also a good question, and I can't answer it for every judge. This issue is one reason why so many jurisdictions now have developed enhanced sentencing requirements when a person is over a certain age and they are the victim of a crime. I mean, the facts that are given to the court in the course of the trial or at the time of sentencing, or if there's a victim impact statement, which elders can provide, will end up making a difference to most judges. So.
Judge Howze, this is Andy again.
Yeah.
I was wondering if you could talk a little bit about what types of training judges receive and whether or not there is information you think that judges may not be getting that would be helpful to judges, in addition, obviously, to webinars like this one. But I think people would be interested to know sort of what types of ongoing trainings judges have. As you mentioned, the fact that laws change over time, attitudes change over time. And so the question is, how do judges get training? And is there more content that could be developed that would help judges be trained on these issues that you've talked about?
Okay. One of the things, and this is under the auspices of OVC, but the National Council, in partnership with Futures Without Violence, a San Francisco program, we all developed a elder abuse curriculum. And what is beautiful about this curriculum, it was developed in connection with curriculum being developed for prosecutors, for law enforcement. So we're all kind of talking the same language on this elder abuse issue. Those trainings, I believe they're held once a year, and we usually end up with 35 to 50 people, judges. It's only judges. We go through all of what we talked about today, but in more detail. And we also press the point of judicial leadership. The people who participate, and this was purposeful, they're not all probate judges. The people who come, the judges who come for the training, can be from criminal, they can be from probate, they can be from family court, they can be from the jurisdiction's DV, Unified DV court, they can be from I think that, the civil division, where landlord-tenant issues are happening, so that we're trying to infuse at least 50 judges at a time with the concepts of what do you need to look for when somebody shows up in front of you. Because we don't have something called an elder court. Just because you're 65, you need to go over there for whatever you're in court for. So it's about awareness that this is hidden, and it shows up in ways that you would not expect it. The other thing that I'll say to you all is every jurisdiction has either annual or twice a year judicial training. And what has happened over the last, since actually we started doing the training through OVC sponsorship, you start seeing this issue show up, even if it's for an hour-and-a-half session, with a combination of judicial engagement, advocacy engagement, prosecutorial or law enforcement engagement. So it's not just some speech about the issue, but how are you supposed to work together to keep up with what's developing in the area of later in life abuse.
Thank you, Judge.
I hope that answers your question.
No, that was very, very helpful. Another question is, you talked before about the importance of balancing protection versus autonomy. As a judge, how did you do that? What factors and considerations did you find the most compelling to try to navigate that and find and strike the right balance in a particular case of where that line was? I imagine there must have been situations where you talked about, obviously, the safety of the individual is paramount, but there may be times when it comes very, very close to being unsafe, but not quite, and yet you want to maintain their autonomy. How did you work your way through those types of cases when you had them?
I think that's where the importance of getting more clear about how do you define capacity. And I say that because you can have all kinds of exams that really are not assessments, they're screenings. And judges have to know what instruments should I be looking at. So I want to balance safety with autonomy. The ward is saying, I don't want that person in my life, okay? I know as a judge from the evidence that I've heard that there is a safety problem with this person. Now then that becomes a conversation. I might not have it directly with the ward, but I may send the parties out and say, see if this ward will suggest somebody else that they want to assist them, and narrow the level of what that person's responsibilities are going to be. You can always ratchet it up, but once that autonomy is taken away in a guardianship, it makes it very difficult for the ward, because now we've added something else that can cause depression and other symptoms and weaken the person just simply because they're emotionally distraught because somebody is intruding into their life.
Right. You talked before also about the importance of making sure that the voice of the older adult is heard during the proceeding. As a judge, did you have situations where there was a proceeding where the voice of the elder wasn't heard at all? And how did you basically make the parties make sure that the voice of the elder, the wishes of the senior, were made available to you? Like, how did you do that as a judge?
Well, actually, I did not have to do it, and that's simply because of, I think, the fact that I did not sit on a probate calendar as a judge. I can only go from my experience as an attorney. And see, that's where it takes all sorts to make the village for the older folks, because as an attorney or guardian ad litem, I knew what I needed to bring to the court. And that's where it's important that these discussions happen, not about a specific case, but what is our system going to be to make sure we get the best information we can get so that we can proceed appropriately with this elder. Now, in criminal cases, you know, I did have a couple of DV cases that it was clear to me from my experience that there was a problem and with the defendant. And in one case, a probate lawyer came in to defend the person. I knew this guy was a probate attorney. So what I did, I asked him, I said, is there a pending probate case? Because you could tell from the facts that something just wasn't quite right, okay? He said, yes. I said, okay, when are you going to have your determination of capacity? And clearly you could look at the guy and there was something going on, okay? I can't determine from looking that it was an issue of capacity, but my next step as a criminal judge would have been to order this guy to do a competency exam. Now we've got an 80-year-old who is seriously having some issues that has to go to two different kinds of exams, which are for two different purposes. At that point, I can say to the prosecutor, can you wait until we get the results from probate before we proceed? Well, within 2 weeks, the case against the criminal case was dismissed at the request of the prosecutor. So it's that kind of almost subtle stuff that is what we're talking, that's what we're talking to judges about. That you can't necessarily have some hard and fast rules that you're going to follow, but you have to know what information you need to get the full picture of this person and this person's life and this person's situation.
Thank you. Another question was regarding the importance of accommodations. I think this dovetails with what you were saying. being sensitive to the fact that seniors may be on different schedules, they may have different needs, and making sure that the system is accommodating to make sure that they are able to participate meaningfully in the process without being scared or without being threatened. In terms of training, do you know whether or not these types of efforts to either raise awareness of the type of accommodations that seniors may need, do you know if that type of information is being conveyed to judges now? And if so, how that is being conveyed? Is that being conveyed through these annual conferences that you mentioned, or are there other avenues that judges can go to if they want to learn more about how to make sure that they're sensitive to those types of needs of older adults in the judicial setting?
Those issues are discussed during the annual trainings that we have held because it's part of our curriculum. But Stetson University down in Florida, they created a elder courtroom. And I can't call off the top of my head the professor's name, but
Professor
she goes
Becky
around.
Morgan?
Yes. She goes around the country and talks about how they developed it, the importance of having accommodations, and the impact it has on the life of the senior. And people are asking her to come to do that. So, it takes a while, but the word is getting out. I mean, there were issues that come up with people who need oxygen. So
Right.
Let's say I'm the criminal trial attorney, trial judge, and should I ask when I see that somebody comes in and they've got a tank and we're ready to go to trial, we need to have a conversation about how long do you think this trial is going to last? Do we need to have medical support available? Is it possible to bring another tank in case it goes longer? Those conversations generally weren't happening. And I think they are beginning to happen because people are becoming more aware of the fact that elders who are probably because of the change in population and the aging population coming into court more frequently than they did before on lots of fronts. You think about the grandma who is raising her grandson. 15 years ago, that woman would not have been in court. Today, there's a strong possibility she would be in court for a number of things. 15, 20 years ago, she would not have had to apply for custody. She would have just had her grandson. We have changed processes that are bringing older people in the legal process in ways that they probably did not expect. And that's part of the accommodation issue.
Right. Okay. Judge Howze, we thank you so much for taking the time to share with us some of your thoughts and experience and wisdom on this issue. You are a pioneer on these issues, and we really appreciate what you've been able to share with us today. For those on the call, we hope you have found this informative as well. And with that, I think the time is up. So thank you again for participating, Judge Howze, and for all the people who participated on the webinar. Have a great weekend.
Can I ask one more thing before we go?
Please.
On the bottom of the PowerPoint, you have the website for the National Council. Feel free to go there. There are plenty of materials and also links to other organizations like Futures, to Stetson, and there's a wealth of information that you can all use. Thank you.
Terrific. Thank you very much. So long, everyone.
Great. Thank you so much for joining our webinar today. If you have any additional questions, please feel free to email the Elder Justice Initiative at elder.justice@usdoj.gov or visit the website www.elderjustice.gov. And that concludes today's webinar. Thank you.